Well, good evening, everybody, and welcome to the International Practice Panel. I hope that you will enjoy this evening's range of international issues, which we have an excellent series of speakers. A couple of housekeeping points to begin with. First of all, the event is being recorded and will appear on the Inner Temple website in the next few days. So a link will be sent to everybody who's participated after the event. If you want to ask a question, please use the Q&A function, which you'll find to the bottom of your Zoom page. And then the questions can be put to the panel at the end of the various talks. If you want to upvote a question, then use the thumbs up button if you want that particular question answered. We're aiming for the talks to end about 6:30, and then for us to have something in the region of 25 minutes of questions at the end. So without further ado, I'll introduce first of all Tom Weiselberg QC, who's going to talk to us about international arbitration and international civil fraud.
Thank you, Master Flaux. I'm a tenant at Blackstone Chambers, and I was called in 1995 and took silk in 2014. And I specialise in commercial and public law. I'm predominantly, however, a commercial practitioner with a particular focus on civil fraud, arbitration, and media work. And my international work falls mainly into the first and second of those three areas. By way of practice development, I arrived in Chambers as a pupil expecting to be interested in public law, but I quickly became gripped by commercial work. Why? I love the urgency, the complexity, the cut and thrust, and the strategy that commercial work requires. There's a satisfying mixture of hard-edged, black-letter law issues and more nebular issues, such as commercial considerations and litigation strategy. And I fell into commercial work initially through my particular pupil supervisors. I had a pupil supervisor who specialised in obtaining worldwide freezing injunctions and search orders, thus fraud. I had another supervisor who specialised in acting for musicians, thus media. And about those areas, what's not to like? You can go out and have supper with friends and you can tell them about interesting musicians who've been involved in fraudulent practices. But their work and my work initially was mainly domestic in nature. The arbitration work came later, largely as a development of my commercial work. So fraud cases with an arbitration angle or media cases with an arbitration angle. Their sector-based knowledge got me instructed by the arbitration department, and I then expanded out of the particular sector. So I did an arbitration about telecoms, and then I was instructed to do an arbitration about oil. As for the international side, I'd always been interested in working abroad. And before coming to the bar, I'd worked in New York, Mexico, Germany, and Hong Kong. And as a result, I always wanted to have an international element to my practice. And at the end of my first year as a tenant, I therefore applied for and got a Pegasus scholarship to Bermuda and the US. It was great fun to do, albeit neither place directly generated any instructions. In fact, the international end of my practice came later and developed out of my domestic practice. And for me, international practice falls into three main parts. First, you have foreign law. So I've done a large number of cases in the UK, both as arbitrations and in the High Court, that have involved a host of different foreign laws. So I've done cases that involved Russian law or the law of Kazakhstan, Kuwait, Angola, Switzerland, Djibouti, France, New York, and Bahamas. And through those cases, I've met and developed relationships with foreign lawyers. So that's the first area. The second area is foreign clients. And I've acted for a number of clients from a number of different countries, many from the former Soviet Union, some from Nigeria, Kuwait, the Yemen. In particular, I acted for a Russian client, and as a result of that case, I went to Russia 18 times in 18 months. But Russian clients have also taken me to the BVI. Indian clients have taken me to the Cayman Islands. Ukrainian clients have taken me to Switzerland. And Djiboutian clients have taken me to France. So that's the second area, foreign clients. The third area is foreign cases. Now, those are more difficult, certainly from my perspective, to acquire. Having experience of the first two areas helps. And that then allows you to get, for example, called to the BVI or the Cayman Islands. I was admitted to the BVI as a junior barrister for a particular case, but now the rules have changed and you can only be called to the BVI for a particular case. It's much more difficult unless you do pupillage, either there or, for example, in Hong Kong, to be called generally. And similarly, in the Cayman Islands, it's necessary to be called on a case-by-case basis. Now, as a junior barrister, that can be difficult, but it remains possible as a junior barrister to be involved in those type of cases. Even if you're not called to the particular offshore jurisdiction, you can work as a support lawyer, either in London, so you provide a 24-hour service for a leader in Hong Kong, or in the local jurisdiction. So I've often seen juniors traveling out on the same flight as their leaders so that they can be in court and they can do exactly the same job, albeit they won't have their name actually on the list of people who appeared in the case. I've also done a lot of international arbitrations. Some of those are seated in London with, for example, a French arbitrator or an American arbitrator. Some are in Paris. So I did 2 arbitrations in the last 2 years in Paris, and I've got another one, all being well, from a pandemic perspective later in the year. And I've also got another one in Dubai. Now, some of those cases I've done abroad as a result of instructions directly from the offshore firm, but some have come from solicitors who instruct me in London. So by way of example, I was the Cayman arm of a multi-jurisdictional arbitration award enforcement case being brought in London, Mauritius, and Cayman. And there I was chosen by the London firm, but on the back of that case, I established a relationship with the offshore firm and have worked for them on a number of cases thereafter. Now, why do the work? All cases have lots of dimensions, but for me, international cases have added dimensions and they've got added spice. So using the same 3-fold category that I mentioned a moment ago, foreign law, the foreign law itself and the approach of foreign lawyers to that law is interesting. Foreign clients are exposed to particular forces that a purely domestic dispute will tend not to have. Their own judicial system, their own political system, or the manner in which business is customarily run will be different. And it's interesting to become immersed in their world and work out how to explain that world to an English commercial court judge. Foreign cases also lead to exposure to foreign arbitrators and foreign judges, and that's good for your advocacy. The ICC arbitrations that I've done have 3 different arbitrators, all foreign lawyers with different jurisprudential experience. Some are civil lawyers, but some are based in Commonwealth practice, and one needs to tailor one's advocacy to the particular tribunal that one's appearing in front of. So you need to be flexible. You need to be inventive. What works for a commercial court judge may not work as well in front of a panel of civil law practitioners. Your cross-examination style may need to be adapted. Basic principles may need to be explained. So I've had a case where I had to explain the English law of implied terms from first base to an arbitrator. And you have to work out how to be your most persuasive. For example, I had to work out how to entice an offshore judge who just returned grumpily and reluctantly from a beach holiday, who had no particular experience in fraud work, that it was really appropriate and necessary to grant a worldwide freezing injunction for $500 million then and there, rather than to adjourn the whole case, because it was going to take a bit of time and a bit of thought, on notice for 2 months until the beginning of the new legal term. But fourth, there's a whole other reason, and that's travel. And in the pre-COVID world, travel could be tiring, but fun. in the post-COVID world, I suspect you've all spent too much time at home, and the prospect of travel to foreign climes may be particularly enticing. Now, I've tended to work really hard when I'm abroad, midnight finish, 6 a.m. start, but there are benefits. I've eaten excellent Italian food at midnight in a Russian hotel in readiness for a 6 a.m. start the following morning. I've walked around Wed Square for an afternoon, albeit that having been in Moscow for 20 weeks of my life, that was all I actually saw. But now I do try to take some extra time in the foreign cities. I try and go to a concert on the Saturday night. I maybe go to an art gallery before catching the flight home. I maybe drive around the island on the Sunday before the hearing on the Monday. So there are lots of different types of work that one can do. And I'll just give you a few brief examples. An ICC arbitration in Paris for a Middle Eastern government in relation to telecoms and oil. A claim in the BVI for a Russian bank in relation to defaults under a loan agreement. A claim in the Cayman Islands for a Norwich Pharmacal order in relation to an arbitration award worth $1.5 billion. It's fun and it's interesting. How to get the work? It seems to me that you should use domestic work as a lever. Attend international conferences as a junior barrister. Fraud lawyers and arbitrators love a get-together. Dublin, Geneva, Miami. Write articles, blogs, give talks. I'm giving a talk on Wednesday to about 350 international lawyers about search orders. I'm hoping that it will generate international work, either in this jurisdiction or abroad. That's my time. Thank you very much.
Very much indeed, Tom. Next up, we have Mavis Amonoo-Acquah, who's going to talk to us about international family law.
Thank you, Master Flaux, and good evening, everyone. I am a family law barrister at Harcourt Chambers, and at the current time, my practice encompasses the full range of family law areas. So that includes private children work, so for example, child arrangements following separation, public children work, which includes care and adoption work, and divorce and ancillary relief proceedings, so that's division of assets following divorce. And of course, of particular interest this evening, international law is also some of the work that I do in terms of family law. And I think when we consider the global world that we live in and how easy it is to move from one place to another, it's obvious, isn't it, that familial disputes will get caught up in that and therefore throw up questions of competing international law. Now, international elements of family law appear in both children work and divorce and finance work, but of course they operate in very different ways. I should say, however, that it will get you far fewer air miles than we've just heard about with international arbitration and civil fraud, because nearly all of our work takes place in courts in this country. So that's one thing to bear in mind if you're looking at international family law. There are fewer sunny islands and Russian red squares to go to. But in respect of divorce and finance, a case could involve marriages or divorces which have taken place abroad and the parties seek to litigate here regarding their assets, or vice versa. And there may also be disputes about which country is the most appropriate one to litigate in, because you may have a party who wishes to litigate here thinking that it may be of greater benefit to them than litigating in another country. In respect of children law, which is largely my practice area, international family law comes into play in the area of child abduction work. So that is where one parent wrongfully removes the child or children from one jurisdiction to another without the permission or sometimes even knowledge of the other parent, and that would be an unlawful removal. So how did I get here, which is the question I ask myself all the time. How did I end up practicing in this area of law? Well, I became interested in family law in general at university. I studied it as part of my undergraduate degree. I didn't actually choose to study international law during my undergraduate course. So my first foray into international law and law as they apply and operate in other jurisdictions arose from my master's degree. I studied for my master's, my LLM, at the University of Pennsylvania Law School in Philadelphia. So whilst I was out there, I was studying American law. And after undertaking many pupilages before my master's as an undergraduate, I had decided that I wanted to pursue a career at the bar and also specifically a career in family law. So in light of that, during my master's degree, I undertook a course in family law and divorce, and that was focused on the law as it was in the state of New York. In this class, we looked at a number of different case studies which involved international issues. So for example, divorce cases where the family had assets both in the USA and abroad. There were cases where one parent sought to relocate outside of the States with the child, and so there was a dispute about, first of all, whether they should have permission to relocate with the child, and if they should have permission, how that child will maintain their contact with the parent who remained in the States. And of course, there were also cases involving unlawful abduction. And all that kind of work is the kind of work that I do now as part of my international family law practice. So that was a really great insight into seeing that at a very early stage, because they were not new principles which I came to see when I came to my own practice in the UK. And of course, I think doing my master's abroad gave me my first insight into and experience of international law, and in particular, I would say consideration of how international law can come into play in family law specifically. And it gave me the chance to, I think, examine and compare the ways in which the laws of the two jurisdictions differ and why. And this ability to look at different laws comparatively is something that I came to build upon later on in my practice as well, which I'll touch upon in a moment. I then came back to London, undertook the BPTC, and whilst doing so, I interned at the Coram Children's Legal Centre. And in light of my interest in international family law and its operations, I was placed in their international department, which was brilliant. And during my time there, I worked on the department's research projects, which had been commissioned by the United Nations. And it involved looking at family law in other jurisdictions, and also consideration of international instruments such as the Convention of the Rights of the Child. And this work undoubtedly broadened my knowledge and interest of the international instruments which currently exist and which form a lot of the basis we use here in the UK. So having taken all that experience and applied for pupillage, and having gone through pupillage and now as a junior tenant, my international practice now encompasses child abduction work in the High Court, cases involving competing jurisdictions, and also the applicability of family law mirror orders in other countries. And it's, I would say, a very interesting area of law. It's in light of all the different areas in family law, I would say it's the most black letter area of law. And I think the case law speaks for itself as to how interesting it is and how varied it can be depending on the facts of each case. I would say that another area of my practice and interest, and an area of law which is undergoing substantial growth at the moment, is surrogacy law. And technically, that is a domestic area of law, but it can have international elements. So, for example, if a baby is born to a surrogate mother abroad, but the intended parents want to bring their child to the UK and raise that child here, and that raises an international element to those proceedings. But surrogacy law, as it currently is a very underdeveloped area of law in the UK. So for some time now, we have been looking towards other jurisdictions and observing how their surrogacy laws work in practice, in order to inform our proposals for surrogacy law reform in this country, which are currently in train if anyone's interested in that. And so because I was very interested in this particular area of surrogacy, and because it was a growing area of law where we were looking at other countries and looking at reform, and again, in light of my interest in comparative law, which I touched upon at the beginning, I applied for a Pegasus scholarship again in a temple, which I was lucky to receive in 2018. And as part of my scholarship, I proposed a placement in Los Angeles for 3 months with a law firm which specialised in surrogacy and fertility law. And that secondment gave me a key grounding in Californian and UK surrogacy law, which I have been able to use and build upon in order to build my practice in this area. So like you've just heard, I've been able to give talks and write articles and obtain work through that mechanism following on from my scholarship. So just building on that work and building it into my practice. So that has been my journey into international law and the work that I do. And I think if I were to look towards giving practical ways to get into international work or family law, or to build an international part of your practice into your main practice, what I can take away from my experience so far is that, first of all, find the area of law which interests you. So for me, it was international family law as it pertained to children work, and surrogacy more so than divorce and finance. And for others, it might be divorce and finance and the international elements which relate to that work. I would then say seek out every possible avenue and opportunity to obtain exposure to that work in order to build your knowledge of it. So for some people, that may be academia through a further degree, or a short course, for example, or for others, it could be practically in terms of interning with a particular organisation or a law firm, for those of you who are still seeking pupillage or at bar school and able to undertake that work. And I think thirdly, there is also just the age-old practice of simply being proactive and familiarising yourself with the applicable laws, international instruments, cases and practical guides, and just build your knowledge in that way, so that if an opportunity comes to you as a junior member in chambers, you're able to say to your clerks, look, I know this work, I can do this work, I know how it works in theory. There are other senior members of chambers who I can ask for the practical side of things, and make yourself marketable. So you're always standing ready to take the opportunity if it should come to you. I should also say finally that I think I've been very fortunate to obtain tenancy in a chambers which has an excellent reputation for international family law. So a lot of work does come into chambers that way. But as I say, it's making yourself attractive to solicitors, it's making yourself ready and available. But for those of you seeking pupillage at the moment or tenancy, it always goes back to the issue of not just seeing if you are a right fit for that chambers, but seeing if that chambers is a right fit for you. So if you know, for instance, that you're interested, say, in international family law, you ideally would be looking towards or hoping to obtain pupillage or tenancy in a set that does that kind of work or gets those kinds of instructions to help your practice along a bit. So never forget to also make sure that chambers is as good a fit for your aspirations and your practice areas as you are for chambers. So I think that is me in international family law. Thank you very much.
Thank you very much indeed, Mavis. Thank you. Next up, we have Natasha Jackson on human rights.
Thank you, Master Flo. Good evening, everybody. Yes, I'm a barrister at 3 Harcourt. I was called to the bar in 2015, and I have quite a varied public, commercial and civil practice, and most recently represented Camilla Batman-Gelage, who was founder of Kids Company in the High Court disqualification trial that's making the waves on Women's Hour this week. But I also have an international focus to my practice, which includes private international work, which is work on conflicts of law and jurisdiction, work in Commonwealth jurisdictions and asylum work overseas. The topic I'm going to be talking about this evening is human rights. So I'll be talking about my international work in this field. But I also, like Tom and Mavis, would like to speak a bit more holistically about opportunities to work internationally and take an international approach to practice at the junior bar. I think there are lots of ways in which a practice can be international. So I'll try and pick out some of the ways that I've been able to do this so far within my practice and try and give some pointers on how to build an international practice in the early years of tenancy. Just briefly, in terms of my own path to the bar, I did a history degree at undergraduate. I went straight into the DDL, straight into BBTC and straight into pupillage. And I've been at 3 Harcourt for 6 years now. But my initial intention was to work for an international NGO on human rights or environmental issues. And I initially decided to become a barrister to have a professional toolkit to work in that space. So I've sunk into my domestic practice now, but my desire to be professionally engaged in international issues hasn't gone away. Also relevant is that I have never had a gap year and somewhat regret that, which is something I'll come back around to talk about in the second part of my talk. But first, to talk about human rights practice. The first thing I wanted to talk about was my work on the Iraq fatality investigations. So the Iraq fatality investigations, or the IFI, is a sort of hybrid between a coroner's inquest and a public inquiry into civilian deaths involving British forces in Iraq. And Baroness Hallett is currently the inspector. The IFI is an Article 2 investigation, which many of you may know already is the right to life, but that carries with it an investigatory obligation on the state. The IFI was established following litigation which confirmed that the jurisdictional reach of the European Convention of Human Rights extends to territories in which a contracting state exercises public powers, which was the case in Iraq during the war period and the period of occupation. In my role as counsel to the investigations, my work involves advising the inspector, so Baroness Hallett, on questions of human rights law and international humanitarian law. For example, in a recent investigation that we did into the case of Tariq Sabri Mahmood, we had to consider his prisoner of war status as a deceased individual who died in transit by British helicopter from an Australian capture point to an American base, and the implications of that under the Geneva Conventions. We're currently giving consideration in the investigation to the use of particular interrogation techniques and their legality under human rights law as part of an investigation focusing on policing practices in the post-war phase. So this is work that involves international law and has an international backdrop, but is in a domestic inquiry context that's scrutinizing state actions. Another thing I wanted to mention in relation to my human rights and international humanitarian law practice is work that I've been doing with a predominantly academic team advising the Free West Papua campaign on various matters of international humanitarian law relating to the struggle for independence in that territory. This raises questions that I find really interesting relating to campaigns for self-determination under international law. But the reason I wanted to mention it for this talk in particular is that this is something that me and my colleagues are doing pro bono through an organisation called Advocates for International Development, which is an organisation that pairs lawyers with international projects. Now, I'm not bringing that up to virtue signal, but hopefully to make a point that those who need their human rights upheld often don't have deep pockets, and that for those starting out in the field, there are a wealth of opportunities to take on really valuable, really interesting pro bono work through organisations like A4ID, if you're willing to do it for free. There are different models that you can use to kind of build that into your practice. But personally, as I said at the beginning, I have a quite broad practice that includes commercial law and civil law as well. And my model is that I have one part of my practice that generates my income so that I'm able to do projects that are kind of heart projects that often don't have price tags attached to them for free. The second thing that I wanted to draw attention to that comes out of that work is that more than some areas of law, human rights issues are rarely confined to the courtroom. And so depending on how you're inclined and what your background is, it may be that it's a field that you can engage with through academic work or participating in public discussions. So I'm really happy to take any questions on my international human rights law practice, but I did want to give some more time to talk about international practice more holistically. And this is something that Tom and Mavis have both touched upon already, but the first thing that I wanted to mention were opportunities to work abroad. For me, international is not just the substance matter of practice. I want to live in a world and not a jurisdiction, and that's where the gap year point comes back again. I've got itchy feet and want to use them. So I've been particularly driven to sniff out opportunities to take my work overseas. One way in which I've been able to do this is with my asylum work. I have a domestic immigration and asylum law practice, and that obviously engages an international framework and a European framework of law. And that means that I have been able to use the skills that I've gained as a British barrister to take that work to volunteer it in clinics in Athens and in northern France. So in particular, there's an organisation, RLS Athens, that has a clinic established in Athens and also one in Lesbos. And I've been volunteering with that organisation for about 4 years now in Athens, as well as doing remote work from the UK. So to me, this work demonstrates that the qualifications and skills of being a barrister in England and Wales can be used overseas. Also, if it hadn't been for COVID, I would last year have travelled to Palestine to observe the Israeli military courts as a Bar Human Rights Committee observer, which again, I think ties back to the comment I made earlier about being able to work with organisations that that do human rights work that might be of interest to you. I think the next point that I was going to talk about is one that has been well covered already, but you know, three's a crowd, and that placements, secondments, scholarships, and in particular Pegasus scholarships, I think can offer a real opportunity for junior barristers starting out. The Inns of Court obviously have a global membership, and the Inns facilitate really wonderful opportunities to arrange exchanges and placements across borders. At my chambers at 3 Harcourt, we've had the pleasure of hosting through the Inns and through various other programs junior practitioners from the Commonwealth and from South America, and colleagues have done placements in the USA and in the Strasbourg Court. Again, if it hadn't been for COVID last year, I would have been in Beirut and The Hague on a Pegasus scholarship to work on transitional justice at the Special Tribunal for Lebanon. So hopefully that opportunity is still there when it's possible to travel. The final thing that I was going to talk about as part of my kind of holistic section of the talk was the participation in an international community. I was really fortunate when I was a BBTC student to be awarded a scholarship from Inner Temple to join a masterclass being held in Dubrovnik that was run by Jeffrey Nice and his foundation, which was focused on the workings of the ICTY. This has developed into an active working group involving members of the international judiciary, leading lawyers from across the globe, including Andrew Cayley, who I think is going to be talking to you a bit later, and junior academics and practitioners like me. And this has been a real opportunity to benefit from engaging with lawyers from different contexts and from different countries. Also, I think Tom mentioned this already, but membership of international bar organizations and being able to attend international conferences is a good way of being able to engage with an international community as a junior lawyer. In addition to the Inns of Court, there are organizations like the IBA or AIJA, which is a junior lawyers association, both of which have human rights sections if you are particularly interested in that field. And attending international events can give an international flavor to your practice and, like I said, engage with lawyers from different contexts. A lot of this has obviously moved online over the past year, and that can actually give an additional opportunity to engage with people from across boundaries in a way that wouldn't necessarily have been happening so much before. A little less exciting than being able to travel to the conferences perhaps, but still a really good way of engaging. So I think that's my time up. I hope this has given a fairly holistic view of how a junior practice at the bar might look international. And of course, I'm happy to take any questions.
Very much indeed, Natasha. Next, we have Master Desiree Artesi, who's going to talk about Privy Council and Caribbean practice.
Thank you very much, Master Flaux. I thought I would divide my brief talk in 4 parts. First part, I'll talk about how and why I have an interest in Privy Council and Caribbean work. Second part, I'll talk about a bit about the nature of my Privy Council and Caribbean practice and give you some examples of the type of cases I'm involved in. Third, I'll look at what I found most interesting, rewarding, and/or challenging about the work. And then finally, how I've developed my practice, some tips, which I think is what most of you want to hear. Looking first at how and why I have an interest in Privy Council and Caribbean work, you'll note there's a breadth to my practice, and it's mostly because I adopted a bloody-minded resilience and determination to first of all practice in areas of law that interests me. And you'll see that chimes with what Natasha has been saying to you. I had an adopted pupil mistress, Claire Miskin, sadly deceased now, and she was a great constitutional and administrative law practitioner. And we'd spend hours in her room talking about the finer points of judicial review principles, homelessness judicial review, which is one of the areas I started off practicing in. They used to be heard in the High Court and then moved to the County Court statutorily, and then go on into more areas of public procurement and that sort of work. And so she instilled in me a great love for the intellectual challenge of constitutional and administrative law. In terms of the Privy Council work and why I'm drawn to it, I was born in what was then British Guyana and undertook my early years of schooling in Guyana, St. Lucia, Barbados, and the Bahamas. So you can see that there's a very close affinity. And chiming with what Tom has said before, I'm actually called to the bar in St. Lucia with the ability to practice in the entire Eastern Caribbean. But I've come to understand the importance of upholding the rule of law through my volunteer work in Africa and Latin America. And this is something you've also heard from the previous speakers. So for example, in January to about the 17th of March last year, just before lockdown, I was returning from a volunteer stint in a township called Masipuluweli outside of Cape Town. And I've also volunteered in Brazil and Nicaragua and have lots of colleagues and friends who are lawyers there. And what that has primarily taught me is the importance of the rule of law to a nation's self-determination. And I'm so very proud of the excellent rule of law record enjoyed by the Caribbean and want to contribute to that continued success of that. In terms of the nature of my Privy Council and Caribbean practice, just some brief examples. The Judicial Committee of the Privy Council, for those of you not aware, is the final appellate court of 9 territories of the Caribbean. So for example, at the moment, I'm currently instructed in a very interesting appeal representing the inhabitants of the island of Barbuda. And the challenge there is to a parliamentary act called the Paradise Found, in brackets, Project Act, bit ironic, the name, which the Barbudans say the Antigua Parliament passed to facilitate a massive development on the island of Barbuda, and that act is unconstitutional and invalid. The respondent is the Attorney General of Antigua and Barbuda, but one of the developers is Robert De Niro. So it's extremely interesting. Another case I've been involved in related to a challenge as to whether an administrative law action reliant on the Eastern Caribbean civil procedure rules was available to a cabinet appointed employee who was summarily dismissed over the local radio. Another example is where I represented the government in this case on a challenge to the constitutionality of statutory civil freeze and forfeiture money laundering regime. So immediately you can see from the breadth of the topics, there's a crossover with employment law. In the context of the civil forfeiture, you cross over with criminal confiscation proceedings, but that brings me nicely to what I find most interesting, rewarding, and or challenging about the work. The example I've given you earlier of the Barbuda case, what is a matter of record in relation to the island of Barbuda is that the island was owned by a Sir Christopher Codrington, who was a Barbados-born colonial governor. He was very wealthy and gave a large endowment to All Souls College, Oxford, for the Codrington Library. But it also appeared that part of Barbuda, which is the subject of this controversy, was given as a legacy with the effect that the present-day Barbudan people run the island by a council, and that has been enshrined in legislation, although currently the subject of all of this controversy. But leaving aside the legal issues of the case itself, there's a whole level of historical records which make fascinating reading. And if any of you are interested in that sort of thing, I promise you a read of colonial dispatches to the Foreign and Colonial Office and its previous incarnation at the beginning of the 19th century make fascinating historical reading. So as you can imagine, these cases raise important points of law of public importance, and the decisions of the Privy Council have wider implications for the entire 9 territories of the Eastern Caribbean. And the challenge there is to get to grips with the applicable legislation in relation to the island concerned, the appeal in which you're dealing with. And not just that, because there is a symbiotic relationship between the islands, you've also got to have a grasp of what the legislation is in all the other 9 territories, because although they're broadly similar, there are often some very serious and substantive distinctions. And then you've got to get on top of the UK case law and Australia sometimes, and some of the outer Cook Island, New Zealand cases where there's still a jurisdiction in case there's anything there of relevance. And in some cases, insofar as it's tangential, EC law cases. So for example, if you're dealing with an appeal from St. Lucia, they have an added layer of complexity in that that system is based on English common law and Napoleon Code. Another challenge, for example, you can face is, for example, when I was doing the case in relation to the civil freeze and forfeiture regime challenge, I had to get to grips with the UK criminal confiscation regime. Well, I'm not a criminal practitioner other than a brief period when I did a second six, because I was in a common law set. And I highly recommend it, by the way, if you can go out of your way to do a little criminal in your second six, because you'll be miles ahead when you come against people who've had only an entirely civil pupillage. But the major arguments that were being put by my opponent, who was a criminal silk, he was arguing by analogy in the context of the criminal confiscation regime and the safeguards to the UK system. And I had to be able to draw on parallels to rebut those presumptions or lines of arguments. So the requirement is to be able to tackle a breadth of law. And now I come to the bit which I hope you've all come here to hear about, how I developed my practice, some tips. My journey has been in a large part haphazard, interspersed with lots of goodwill and a big dollop of luck. I recall sometime in 2006 or thereabouts, I was instructed as a junior in my first Privy Council matter. And the silk was very distinguished from a Lincoln's Inn set. He was in a different set of chambers and of course had ample juniors in his chambers. So I must confess, I was rather worried about whether I would come up to scratch, or even worse, as can sometimes happen, you get booted off the case. Well, I was invited to dinner by the silk and his wife and the instructing solicitor, who was from the Caribbean, in an Italian restaurant in Covent Garden. And at some point during the meal, the silk turned to me and said, what did the premises we were sitting in remind me of? And I thought, well, it does look like a lavatory, actually. And it turned out that was the correct answer. And so I guess I must have passed muster, but that might have been a test. But I think the lesson to be learned from that is always do your research in advance, no matter what the situation is. So that's your first tip. Now, for those of you who are like me, who did not come up through what's called, whatever that means, magic circle sets of chambers, and where you get a blueprint from day one and the opportunity to work with silks from pupillage, I got invaluable experience from being a junior to that particular silk of the lavatory test, down to color coding of documents in case preparation, which he told me he learned from no less than a then House of Lords judge who was his pupil master. So my journey included seizing learning opportunities in non-traditional ways. So that's your second tip, seize all opportunities. And I believe you've heard that from the previous three speakers. And by the way, the most valuable opportunities can also be unpaid. Finally, one of the ways in which I keep abreast of law in this area of work is to attend the biannual Commonwealth Law Conference, which will be held this year in the Bahamas between the 5th and 9th of September. I must tell you, this is at my own personal expense. I was doing this to help further my practice. But in attending these conferences, I got to meet other practitioners and members of the bar who were all extremely generous with their knowledge and time. And I gained a mentor in no other than Master Dingmans, now Lord Justice Dingmans. And in fact, he kindly invited me to observe him on his feet, probably on the last case in which he appeared before the Privy Council before he went on the bench full time. So I would go to court and observe others. I highly recommend it. I've done this consistently throughout my career at all levels of courts. Lessons learned are invaluable. An example is when I was only about 5 years call or so, I was observing two great silks in the Court of Appeal Civil Division, and there saw costs being argued on an issue basis long before there were dedicated cost reports where you can read about issue-based cost orders. So I hope that has been useful for you. Thank you very much.
Indeed, Master Artesi. Finally, we have Master Andrew Cayley, who's going to speak about international criminal law. You need to unmute yourself, I think.
Thank you very much indeed, Master Flo. Thank you very much indeed for inviting me to speak this evening. It may sound slightly self-deprecating, but I really did not plan my legal career at all and never predicted the way it has in fact turned out. So it's truly been a series of interesting and rewarding surprises. I'm conscious that in saying that and telling you about my path, most of you will want to know where the route begins, or at least how to join the trail halfway along. And I'll try and do that in the time I have. So briefly, I think probably unlike every other speaker here this evening, I started life as a provincial solicitor, and I quickly bored with that and joined the British Army as a lawyer in 1991. And after several years prosecuting in the service courts in Germany, in 1995, I was sent for 6 months by the British government as loan personnel to the United Nations, to the newly established International Criminal Tribunal for the former Yugoslavia in The Hague in the Netherlands. The court had been established by a unanimous decision of the Security Council of the United Nations, acting under its Chapter 7 powers in May 1993. It seems a very long time ago now, and I was looking it up today, to address horrifying allegations of mass criminality in the ongoing civil war in Yugoslavia. It's worth recalling that that was actually a unanimous decision of the Security Council. So China and Russia approved of this court in 1993. I don't think they would do so today, but nearly 30 years ago, that took place, and we just emerged from the Cold War. There was a sense of great hope and sort of international cooperation. I found myself at this embryonic court working on a number of cases, including the first command responsibility case of the court, so the responsibility of a commander for the acts. It's a special form of criminal culpability in international law that a commander is responsible for the acts of his subordinates in certain circumstances. It was the Colonel General Blaskich case. And then subsequently, I worked on the first genocide prosecution before the court involving events at Srebrenica in northeastern Bosnia. That was the industrial killing over 3 days of 8,000 men and boys of Islamic faith in July of 1995. My loan service from the British Army had been extended to a year, then 2 years, and then 3 years. And eventually, I had to decide whether to return to the security of the British Army or resign my commission and take a temporary short-term contract with the UN and become one of its prosecutors. I was in my early 30s with a very young family, but I jumped into the unknown, and I've never regretted that decision. In fact, that decision has made all the difference in my professional life, and I'll come to that. Because of my background in the armed forces, I tended to be assigned to cases involving military commanders. I stayed at the Yugoslav Tribunal until 2005, leaving as senior prosecuting counsel, and still as a solicitor, I went on to the permanent International Criminal Court, also as a senior prosecutor. Meanwhile, since 1998, 1999, a number of very well-known and accomplished silks from across the Commonwealth have been recruited at the Yugoslav and Rwanda Tribunal. The Rwanda Tribunal had been set up a year after the Yugoslav Tribunal to address the genocide in Rwanda. Those individuals included, actually from this instance, Jeffrey Nice QC, who would go on to prosecute Slobodan Milosevic. The president of Yugoslavia is seen by many as the architect of much of the death and destruction of the former Yugoslavia. Then Her Honour Judge Joanna Corner, CMG QC, who would lead in a number of landmark cases at the tribunal, and who's just been elected as the next UK judge to the International Criminal Court. And also Stephen Kay QC, who would be one of the vanguards of the International Defence Bar and who would go on to defend Milosevic. Do excuse me if I've missed any other members of the, and I'm sure there are others who've been involved in trials over the years. At the International Criminal Court, I would work briefly on Uganda, including the Dominic Ongwen case, which has just successfully concluded. And then largely I worked on Sudan, which was absolutely fascinating, specifically in respect of events since 2003 in the 3 provinces of Darfur. That was for allegations of genocide, crimes against humanity, and war crimes against the Fur, Masalit, and Zagawa peoples of Darfur, the perpetrators being members of the Sudanese government and army, and their proxy forces drawn from Arab forces, Arab tribes in Darfur. I spent a lot of fascinating time in Africa, parts of which I fell in love with. That's another story. In 2007, I left the ICC, the International Criminal Court, and went on to defend Charles Taylor, the former president of Liberia. I was led by Courtney Griffiths QC. That was before the Special Court for Sierra Leone. I also defended Ivan Chermak before the Yugoslav Tribunal. In 2010, I was appointed Chief Prosecutor of the Extraordinary Chambers in the Courts of Cambodia, the Khmer Rouge Tribunal, where I stayed for nearly 4 years prosecuting the remaining leadership of the Khmer Rouge for genocide, crimes against humanity and war crimes, principally for the murder and deliberate starvation of up to 2 million of their own citizens between 1975 and 79. And that was an absolutely fascinating period as well. Difficult, but very, very interesting. The end of 2013, I returned to the UK, and you can see from my biographical details have been what I've been doing since then. Surprisingly, for me at least, as the Director of Service Prosecutions, and this is where actually work that Natasha Jackson was talking about and my work intersected, I was involved in the criminal part of the cases involving allegations against UK forces for actions in Iraq. And in particular, the International Criminal Court was conducting a preliminary examination in respect of the work that we were doing. In other words, whether or not the UK was carrying out its obligations properly under the Rome Statute, the instrument that created the International Criminal Court. And that, in fact, that preliminary examination concluded with the ICC deciding that no formal investigation would be conducted against the United Kingdom. And in fact, that took place exactly at the end of my term as director. So that was in November of last year. So that's my career in a nutshell. And I transferred to the English bar in 2007 when I left the International Criminal Court and took silk in 2012 while I was in Cambodia. So the routes into this work. Well, I will certainly let the organisers have my personal email address. And if you're particularly interested, do contact me for a chat and I can see if I can help you at all. So the courts that exist today in the field of international criminal law are the International Criminal Court in The Hague, the Special Tribunal for Lebanon, also in The Hague, principally dealing with international terrorism charges, the residual mechanism for the Yugoslav and Rwanda tribunals, which is the residual body dealing with all residual issues related to the Yugoslav and Rwanda tribunals, which have largely completed their prosecutorial mandate. Then there's the Kosovo Specialist Tribunal, also based in The Hague, dealing specifically with crimes allegedly committed by members of the Kosovo Liberation Army during the civil war in Yugoslavia. And then lastly, the Khmer Rouge Tribunal based in Phnom Penh in Cambodia. For most junior members of the audience, the best way is to do an internship, which is unfortunately an unpaid junior legal position of generally between 3 and 6 months. But whereas they are self-funding, I think in some instances there is opportunity for funding, but you need to look carefully at that, and I can help people with that if that is an issue. It's for a short period of time, normally between 3 and 6 months, but it does open up the doors to more permanent opportunities, both with the courts generally in all of the departments, and also with those conducting defence work before these courts. Internships, in fact, are currently being advertised by the International Criminal Court, because I looked today and I know they're still regularly available at the residual mechanism for the Yugoslav and Rwanda tribunals, also at the Special Tribunal for Lebanon, and certainly at the Khmer Rouge Tribunal, because I actually set up the internship program there. Internships are also available with all of the defence teams working in these courts. And there are defence officers, so permanently established court staff who deal with defence issues in these various courts where you can make inquiry. But I think positions with the defence are often more dependent on actually knowing somebody on a defence team. All these cases tend to be very long, at least a year or so, sometimes several years. So you'll not see the case through from beginning to end as an intern, but you will get excellent experience. For more senior members of the profession, there are, of course, permanent positions available in these courts in all areas, and also with the defence. I would add at the ICC, they have an unpaid visiting professional programme, which is for more senior practitioners and is also up to 6 months experience at the court in all of its departments. So with chambers, in the office of the prosecutor, in the Victims and Witnesses Unit, and in the Defence Unit. You can look at all the relevant websites for information. As I've said, I'm very happy to guide anyone that's seriously interested and wants some support. So to conclude, I believe there are few areas of practice which are as professionally fulfilling as international criminal law. It encompasses domestic and international criminal law, comparative criminal law, international humanitarian law, public international law, and human rights. So there is real intellectual rigor about it, but I think most important, at least for me, there's a sense of professional fulfillment, which I believe is absolutely unrivaled. In Srebrenica, for example, where I was 35-year-old junior counsel, I was part of a case where we confronted state-sponsored denial of events in the face of 8,000 murders. So we're not just up against a well-defended individual, but also a set of governments who needed to defend their own interests in ensuring that we were defeated and the truth remained buried. What we were doing really mattered. That trial was, I think, just over 2 years. I recall cross-examining one defense expert in that case for nearly a month as a fairly junior lawyer. So it was very hard work, but without wishing to sound in any way pretentious, you really felt as if you were part of history, speaking for a very great many people whose lives had been taken in the most brutal of circumstances. At the time for me, Srebrenica and then Cambodia was really beyond anything I'd ever seen or experienced. And I think all counsel believed these events had to be confronted and met head on with everything we had in our legal armoury. It was why there was such a level of devotion and commitment, which was perhaps sometimes evangelical, but it was something that really carried you. Really difficult but great days for me. And I'll finish with this. When the judgment in the first Srebrenica case was delivered, and I remember sitting in court at the time, in Court 1 at the ICTY, Judge Almaro Rodrigues of Portugal, who presided in that case for 2 years, began slowly by stating, "Let justice be done lest the world should perish," said Hegel. You might think hyperbole, but at the time, with those few words, he captured the essence of what this work was all about and the expectation of the thousands of family members who had lost their loved ones. He then purposefully moved to the facts and the heart of the case. Within a few days, approximately 25,000 Bosnian Muslims, most of them women, children, and elderly people who were living in the area, were uprooted in an atmosphere of terror, loaded onto overcrowded buses by the Bosnian Serb forces, and transported across the confrontation lines into Bosnian Muslim-held territory. The military-aged Bosnian Muslim men and boys of Srebrenica, however, were consigned to a separate fate. As thousands of them attempted to flee the area, they were taken prisoner, detained in brutal conditions, and then executed en masse. More than 7,000 people were never seen again. I'll finish there, and as I've said, if anybody is interested in speaking further, I'll give the details to my organiser and you can make contact with me. Thank you very much indeed.
Thank you very much indeed, Master Cayley. Thank you all for the interesting speeches. We've got a number of questions, some of which appear to have been answered along the way. Going back to square one, I'm not sure if Tom is in the process of answering this question, but it seemed to me to be quite an interesting question, so I'll raise it anyway, even though it seems to have appeared on the screen. The question was, if you're not actually instructed as one of the counsel in the case, with your name, as it were, on the cause list in, say, the British Virgin Islands, what effect does that have on recoverability of your fees? And as a consequence of that, really, what effect does that have on issues of competitiveness vis-a-vis local juniors? And I suppose in a sense, at least for those of you who have talked about international practice out in other jurisdictions than England and Wales, as opposed to England and Wales work which involves international issues, it's a question that might actually be some relevance to several of you. So I don't know if any of the rest of the panel wants to say anything about that. Well, I see that Tom has answered the question. I haven't had a chance to look at the answer yet.
Shall I just say what I think the answer probably is?
Thank you.
I think the answer is it will depend on the local jurisdiction. I think some, from a commercial perspective, some jurisdictions will be very familiar with junior barristers tipping up, sitting in the back of court with the onshore solicitors, and there will be little dispute as to the recoverability of the onshore solicitors' costs, and there will be little dispute as to the recovery of the barristers, the onshore barristers' costs. In other jurisdictions, you will have a fight, and then the client may just have to run the risk of non-recovery. And the hope is always that the client is sufficiently concerned about the case to mean that the client will spend the money to get the junior along as well to assist the leader. But that can't always be relied on. In terms of the competition element and how one deals with the offshore-onshore issue, as a leader, I'm always very flexible. And so I always say to my offshore firms, if you want to be the junior, that's absolutely fine. If you want me to get someone in chambers to help out, then equally, that's absolutely fine. And lots of the firms are very happy to provide the service themselves, whether that is cheaper, as either using a BVI barrister, for example, or using the BVI firm, I'm not sure. But that's often the situation where solicitors do it in-house rather than getting external counsel to assist.
Good. Thank you very much, Tom. Anybody else on the panel want to add anything to that? No. There was a question which I think may really have been answered en passant by Andrew Cayley, but I'll raise it anyway. This is from somebody who's currently at bar school, very interested in international criminal law, who asks what's the best way to gain experience and or exposure in the practice area. He's been fortunate enough to visit the ICC, but he's concerned that he wouldn't be able to afford an unpaid internship within the ICL institutions.
So there is money actually available. In fact, interestingly, at the beginning of the International Criminal Court, the decision was made that all internships would be funded because a lot of individuals who didn't have resources were denied the opportunity at the ad hoc tribunals. So we made a deliberate decision to do that, but for some reason they changed the policy after I'd left. There is money available, and I can certainly help people with that. So if you particularly need financial support, it can be done. Generally speaking, they're unpaid, but there is money available in the trust fund, but you have to, at the court for paid internships, but you obviously have to make application, and it's on a merit needs basis, but I can certainly help people with that if they're interested. I put my email up actually on the question and answer.
It's on the chat. Thanks very much. There was another question from somebody who previously asked a question which was answered, but this one is asking whether any of the speakers have had any involvement or have liaised with the Syracuse International Institute for Criminal Justice and Human Rights.
Personally, I haven't, if that was directed at me in any way. I've looked them up and it looks like they're an Italian organisation doing very interesting sounding things, but it's not an organisation I've personally had work with.
Well, presumably it's based in Sicily, is it all? It sounds as if it may be. I certainly hadn't heard of it. I hadn't heard of it, but doesn't mean that.
Yeah, I unfortunately can't help you any more than what I've just ascertained off Google. Okay. But if anybody is interested, I'm sure their website would be a good place to start.
Right. Let me just see whether we have any other questions. Actually, those were the only open questions, other than a thank you from somebody who had to leave, who said it was nice to hear such a variety of experiences, which is a sentiment with which I entirely agree. So unless anybody's got any, oh, hang on a moment, we might have another question that's come up. Oh yes, that's quite an interesting question. Question from Monica, to what extent has speaking another language benefited you in international legal work?
Sorry.
Yeah, and she says preferred but not required. Do some rank higher than others?
I wonder if I could say something briefly, but I know Tom has spoken about his experience of speaking other languages.
Why don't you go first?
Have I got the floor?
Yes, you have.
Well, thank you, Master Flaux. I wanted to simply mention that I speak Italian fluently, Spanish and French, but I wouldn't say that that has in any way benefited or assisted in any way benefited or furthered my work insofar as the Privy Council Caribbean work is concerned. The French is of some use with appeals from St. Lucia because they speak a Creole French there in the Napoleon Code. So that's extremely useful. And I speak both French and the Creole Patois, having been to school there for a while. So it does help if you speak some languages sometimes. They're right. It can benefit you in the most unexpected way in your practice. And I see Tom nodding, so I'll hand over to Tom now to tell you a bit more about his experience. Thank you.
I mean, I completely agree about the unexpected nature. I went to Paris to talk to an eminent French professor about Djiboutian law, and he spoke no English, and the French lawyer decided that he didn't want to translate. So I had to go back to my O-level GCSE French to try and understand what the French professor was talking about. In terms of my Russian work, I think the clients liked it that I didn't speak any Russian, because sometimes you'd ask a question, and after about half an hour of vociferous argument in Russian, where clearly there were lots of different points of view, the answer would come back, Mr. Weisselberg, the answer to your question is no. And that was it. But I wish I'd learned Russian. And I think what I would do if I was instructed on a case that I thought was going to run for a long time is I would try and have some private lessons so that I could at least have some knowledge of the language.
Master Flaux, could I come in?
Could I just add to that, just in passing, because I did the same sort of work at the bar as Tom does. I mean, I speak not quite fluent, but pretty good French. And I certainly found both as a barrister and also I found as a judge that speaking French is quite helpful, because I've had a number of cases which involved having to understand what the witness was saying, and you have an interpreter, and sometimes the interpretation was just flat wrong, frankly. And if you can actually say, look, I don't think you quite interpreted that the way it should have been interpreted, it does help. So I think the answer is certainly if you're going to be involved in international commercial work, an ability to speak either French or German in particular is of some assistance. Does anybody else want to add?
Could I come in?
Yes.
Could I come in? So actually it's interesting because at the International Criminal Court, the two official languages are English and French. And it's a bit of a historical anachronism because, quite frankly, French really is only included because it was the diplomatic language. And although I think it's, it can be useful to speak it, I think other languages are probably much more useful to have. One is Spanish, I would say, in international criminal law. The other is Arabic. Often there are many languages required at the court from Africa, but frankly, some of those are, quite obscure and very difficult to learn. But, languages like Acholi, which was necessary in the Uganda case, I don't think many people in this country, unless they are actually, of Acholi ethnic origin, are going to speak that language. But my advice would be Spanish and Arabic, actually, because I think, as I say, French, yes, it is useful to have it on your CV that you don't just speak English, But I think in terms of the cases that court will be dealing with, those two languages that I've mentioned are the most useful. Yeah.
I just have something, if you don't mind, perhaps just to offer a slightly different perspective, because I completely echo what's been said already. But one of the reasons that I found that languages have been most helpful in my practice has been in the immigration and asylum side of things and being able to engage with clients more effectively. So I found that like I've been learning for far too long, given my level, but Levantine Arabic, for example, is very helpful for engaging with clients who come from that part of the world, who find it helpful to help them distinguish between kind of authority figures and the person who's there to assist them. And similarly, in work in this country, my family's Pakistani, so I've tried to pick up some Urdu phrases to engage with clients who are engaging in the tribunals here. And I just find that actually being able to speak a few words to a client from a different background can be one of the kind of softer ways of building those relationships as an advocate. So that's all I wanted to add.
Well, thanks very much. Let's move on. There's a question here, which is another interesting question. In terms of different styles for different jurisdictions, do you learn that by experience, or would you more openly ask local lawyers about the best way to address their national tribunals? That might be one for Tom to start with, I think.
Yes, I mean, I think it's, as with any tribunal, one tries to find out as much as possible from those people who have experience of appearing in front of them about how they like things to be presented. And so if I'm going to Cayman or going to BVI, I get into discussion quite early on with the firm there about what the judge is like, what the judge likes, and how best to tailor one's argument. Similarly, in the arbitration field, lots of people are well known, and either within chambers people will be known, or again, the firm, particularly if you're instructed later on in the arbitration, will know what the arbitrators like and what they don't like. And then one just plays it by ear, in my experience.
Does anybody else want to add anything to that?
Master Flaux, may I come in?
Yeah.
I echo everything that Thomas said. That's entirely true, whether you're in England or elsewhere. You have to find out as much as you can about your tribunal. But in relation to the Caribbean, if you manage, and I must say it's probably easier for me than most, having been at school in the region, to find out what the local feeling is. Very easy to talk to local lawyers and get a feel for it. But I must say I have a slight advantage in that some years ago, it's probably 5 years now, I went along with Dame Linda Dobbs, carrying the bag, as it were, on an ethics conference. And that gave me an opportunity to meet many of the judges who sit in the Eastern Caribbean Court in a training context. But if you get an idea for knowing who the judges are, which in the Caribbean it can be, you can have the opportunity to do that if you engage in training, or again, going back to seizing opportunities, then you have an idea for the type of tribunal you're appearing before and how they like to be addressed, how they like the arguments to be put before them. And it's no different in a way, as I said, than appearing before a judge in England. If a judge has a commercial background and you're doing a property case, you've got to find a way of getting across to the judge. Similarly, if the judge has a family background and you're doing a commercial case, again, you have to find a way of getting your arguments across. So it's the same principle. That's all I wanted to add. I hope that's helpful.
Is there anything anybody else wants to?
Master Flaux, we do actually have Master Elizabeth Howe, who's the president.
Yes, I saw that. I was going to, in a thoroughly incompetent way, I typed something and was trying to work out how to send it to you.
But she does know about Syracuse.
So what I was going to say was it's probably best if you put her in touch with whoever it was who asked the question, because we've got a few other questions that have been raised that we perhaps ought to deal with. We haven't got that much longer.
Will do.
The next question is an interesting one as well. Can any of the speakers elaborate on the relevance of cross-disciplinary knowledge in an international practice? And it specifically raises Mavis's expertise in child abduction cases, touching on the meaning of the term habitual residence, and is that relevant to, for example, Tom's practice in international commercial arbitration, as the term also occurs in inter-trial model law. Obviously, somebody who knows his inter-trial model law here. But the question is an interesting one, is really the relevance of cross-disciplinary knowledge between different areas of law in international practice. Would anybody like to go on that?
Should I start, Master Flaux?
Yes, thank you.
I think in terms of family law, having experience of any other area of law is of course a bonus. I certainly think that in the majority of the cases that we deal with where habitual residence, for example, comes in, yes, we do sometimes, if we're looking at how to define things, look at how it's been defined in other practice areas. So there of course has to be a level of research. I think the bar is so well connected that if it's not an area that you're familiar with, I'm sure that there'll be a member of another chambers you can go to and ask about and get information from them or guidance as to which area to look in or which direction to look in. So certainly I would say that it's of benefit to have perhaps some working knowledge of other interdisciplinary areas, but I wouldn't say that it's absolutely essential, certainly for something like family law, where we look at our own cases and our own statutes as they were, but we can pick at others to build in further information if needs be. So it's a benefit, but not a necessity, I would say.
We want to add to that or disagree with it?
Yes, and I agree completely with Mavis. I think lots of cases end up becoming, probably unexpectedly, cases that have more than one element to it. So an asylum case that also has a fraud element to it. So people in chambers were doing a case where they were seeking to judicially review the decision of the Secretary of State to send someone back to China, and they were seeking to say that the Secretary of State shouldn't send or allow the person to go back to China because they had confidential information that needed to be preserved in the UK. And there one had a commercial team and an immigration team. But in terms of being a student, how you go about identifying those unexpected correlations, it's not really possible, I think, to do that.
I think that must be right. Well, let's move on. There's the question here, are there any specific qualifications you recommend to those of us wishing to enter into, I think, international law? To summarize, she says she's completed an LLM prior to the bar course, but wondering if there are any other qualifications and experiences that you should aim for alongside mini pupillage, especially as this year there are limited opportunities for mini pupillages or vocational courses. And that's a question which has received 2 up thumbs. So it's obviously something that affects a number of the students who are on tonight.
I think that might be directed at me, so if I may, Master Flaux.
Yes, well, I think it's probably directed at all of you in one sense, but
well, I'm very happy for others to jump in, but maybe if I offer some thoughts first. I appreciate that it must be a really difficult year to start trying to get any experience in the practical fields, and that's hard to navigate. It's not clear to me if your LLM's in IHL specifically, but if you haven't got any direct experience of that field, or have maybe only done a module in the course of a broader program, I think the ICRC have some wonderful resources and some quite advanced online courses that you might be interested in doing. But it sounds to me like you are pretty qualified already if you've already done an LLM in international law. Obviously, many people who practice in the field have done PhDs, but I think if it's a question of kind of killing time in order to get to the bar, that's not the motivation that normally would see you to take on that kind of project. The other thing that occurs to me is that while there might not be as many opportunities at the moment to get many pupillage experience, there is a lot of opportunity to engage in that online community that I was talking about earlier. And maybe this is an opportunity to start writing about some issues that are particularly of interest to you, some debates within the field that really spark your interest. And by putting kind of content out there and engaging with people who find your ideas interesting and bounce them off theirs, you might be able to kind of start generating a profile for yourself as someone with something to say in that field, which I appreciate is not quite a qualification or a placement that you maybe were looking for, but I think it is something that you could kind of use to capitalize the difficulties in doing that at the moment, capitalize on the difficulties.
Thank you very much. Let's move on, because we've only got limited time. There are a few additional questions. Or did you want to say something, Andrew?
Specifically because it was directed, I think, at ICL and National Humanitarian Law. And Natasha's touched on, I mean, I don't want to sort of repeat everything, but there is a lot of stuff that you can do, participate in the UK that you can volunteer for. So, for example, recently I've just done a moot court involving universal jurisdiction in respect of a Saudi pilot bombing Yemen, and it involved an admissibility issue before an English court prosecuting that individual for war crimes. And you know, we always need junior lawyers for that kind of work. If you hunt around enough, you'll find it. That was through GLAN and Swansea University. But as Natasha said, there's always organisations requiring sort of volunteers to sort of wade in and help on these things, and all of that kind of experience is very useful in terms of getting an internship or something more permanent.
Thank you very much. Here's a question which in some senses is quite provocative. How useful is it to have a political background in international law? Anybody want to go on that one?
If there are no takers, I see Tom smiling. Bit of a hot potato itself. Well, I'm not sure. The first requirement is that you have a good intellectual grasp of the law and the area of law in which you intend to practice in. I do have a sort of semi-familial background, which probably can be considered to be political, insofar as the Caribbean is concerned, minor, very minor. If it depends on the area, some areas of practice, and I suspect Tom would probably find this an experience, especially if you're looking at, I don't know, if you're in the Middle East doing international work there, or lots of places, a political background can either further or in fact detract from your work. So I'm not sure how helpful it is. If you're talking about contacts and then getting the work or being introductions, possibly, I'm not sure. But it seems to me, certainly in my work in the Caribbean, the Privy Council, what is very useful to my clients is that I'm impartial, I'm out of the fray, I reside in London, and I come in and they can trust me with some of the most sensitive and difficult issues, and I'm not at all politically motivated or interested. And I think that is far more important, depending on the type of work you're doing.
Does anybody want to add to that? Tom?
Yes, I mean, I think having historical knowledge is hugely helpful in some cases. In lots of cases, it's just about the money. But in other cases where there is a political or a historical element, to understand how everyone's got here is useful. And it's just part of knowing everything about the case. It's part of your case preparation.
Yeah. Thanks very much, Tom. I think that's very, very true indeed from my experience. We haven't got very much time left. There are two questions here, one of which is specifically directed at you, Tom, about a membership of institutions such as the Chartered Institute of Arbitrators. There's also a question about mediation experience, which is probably largely directed at you, but also, I suppose, at Mavis as well. Can we answer those with a written answer offline, as it were? Can I just raise this one, because it's if you could give if you could each give one key piece of advice to aspiring international barristers to inspire our practice development, what would it be? Natasha?
Put me on the spot. I think it probably depends on the stage, and it would depend a lot on what you consider international practice to be. But I would say if you are at the student stage or very early in practice, I would look to the Inns of Court and look at the opportunities that are provided by way of scholarships and placements.
Does anybody want to add to that?
Yeah, I think be prepared to take risks. Actually, I mean professional risks, not stupid risks. But I think that's been the most interesting part of my career. I've been very lucky. I think Desiree mentioned, you know, luck. Luck is a large part of what we all enjoy. But I think it's having the courage to sort of jump into things often gives you opportunities.
I think in a sense that's a very good answer for a successful career at the bar, full stop. Be prepared to take risks and ride the luck that you get. Does anybody else want to say anything about that? Because if not, I was going to finish with, rather like any questions where the last question is always supposed to be a sort of joke question. This is a sort of joke question. Are all international counsel this lively, or are some of them a bore? Is it a fun environment? Who'd like to go on that one?
I think we've
Mavis?
led everyone into a false sense of security that it's it's a bit of a riot. No, but I do think if you enjoy what you do, everything can be as lively as this, hopefully. But I'm glad that we've given someone some entertainment and hopefully some helpful information this evening as well.
Yeah. Does anybody want to add to that? Tom?
Well, I think Mavis's answer is perfect. And if we've made you laugh a bit, that's quite good. And I think, as Master Flaux says, you need to take risks and you need to be unexpected. And that hopefully means that life is a bit fun.
Yeah. Well, very well. We're almost at the very end. So any other questions? If I could ask the panel to try and answer those offline, if you don't mind. And it only remains for me to thank all of the panelists. I hope all the students watching and listening have found this as interesting as I have, because I certainly found it an extremely interesting event. The great thing is we've got 141 participants. I've sort of watched a bit as it's gone on. Very few people have left. That's always a good thing, isn't it? And 141, I think the sub-treasurer would agree, is probably more than we would normally get at a real event. Yes, he's agreeing with me on that. So a tremendous turnout. Of course, it'd be much better when we can all meet in person. But I hope that you have all found this to be a worthwhile way of conducting our international practice panel. And thank you all for participating.